Just cause can be a number of different things, but fundamentally it's the idea that the employee, by their very actions, has repudiated the contract. They are themselves walking away from the contract. An example would be a bank employee that puts $1 million into a briefcase, starts walking towards the exit. That employee is effectively tendering their resignation by their actions, by trying to steal that money. Theft is very often cause. Assault of coworkers obviously very often also cause destruction of property. Those are some of the extreme examples of what would be just cause, but it is a broad and evolving area in terms of what is sufficient to have for an employee to repudiate the contract, to effectively resign based on their actions. An employer is only able to terminate you without severance pay if they have just cause to do so, which means they have cause to terminate your employment. So you've done something as an employee which justifies that employer letting you go. So the standard for just cause is very high. It has to be willful misconduct generally. The employee has to willfully have done something for that to be the case. And the courts in Canada have said that you have to take all the aspects into account. So mitigating factors, whether or not, let's say, the issue took place because someone was addicted to something, or they have personal issues, or because they're worried about reprisals. These factors have to be taken into consideration. But for the most extreme examples, progressive discipline. So an employer just can't say the employee does something one time that's fairly minor, you're terminated, you're out the door. An employee in that case would still get severance. In the vast majority of cases where employers claim that the employee is terminated for cause, the employees in the end do end up getting severance because most employers over-exaggerate cause accusations. For performance issues, the standard for just cause is extremely high, and much higher than even normally is for cause, because it's very difficult to see how employees are fundamentally breaching the contract themselves when they are performing their work. They have to be doing it so poorly that they're effectively not doing their work. Gross incompetence is the standard to terminate someone for cause for doing their own job. If they're grossly incompetent at their job, effectively that they ought never to have been in that job to begin with, and that they are unable to continue in the job. It's very difficult for an employer to meet that standard when an employee has been doing that same job for many years. One would say it's very difficult, as one would imagine it to be very difficult, for an employer to be able to show that an employee who's been, let's say, a supervisor for 10 years is grossly incompetent at being a supervisor, but yet was allowed to be a supervisor for 10 years. The likelihood of a court finding there to be just cause in the absence of progressive discipline, warnings, suspensions, last chance agreements for longer service employees is significantly lower than for shorter service employees. The longer someone works at a job, the more equity they build up in that job, both in terms of protecting them from just cause, as well as in terms of the length of the notice period that they would get if just cause is not established and they're let go from their employment.